Good morning, everyone. Welcome to a meeting of RBKC's Licensing Subcommittee. The hearing is being live streamed. My name, sorry, I have a cough today. My name is Councillor Janet Evans, and I am chairing this meeting today. We are considering an application by the Home Office for a review of a premises license in respect of Diana Restaurant and Cafe, the basement and ground floor at 5/6 Wellington Terrace, London W2 4LW. I confirm that I have no declarations of interest in this item. I am joined by Councillor Marie-Therese Rossi and Councillor Abdullahi Noor. Can I please ask you to introduce yourselves and advise whether you have any declarations of interest to make?
My name is Councillor Marie-Therese Rossi. I represent Redcliffe Ward and I have no declaration of interest to declare.
Good morning. My name is Councillor Abdullahi Noor. I represent Golborne Ward and I have no interest on this case.
And I confirm that I have no declarations of interest. Now, before we start the hearing for this case, just a few ground rules. Please keep your microphones on mute until you are invited to speak, as only 2 people can have their mics on at one time. Please make sure mobile phones are on silent. We're joined by our legal officer, our legal advisor, the committee officer, and the presenting officer. For clarity, I will outline the procedure for the meeting. First, the licensing officer will give a brief outline of the application. Then I will ask the applicant's legal advisor, which in this case is the Home Office, to present his or her submission. He or she will have up to a maximum of 10 minutes to do so. Please, could you confirm your attendance? Sorry?
Good morning. My name is Leonard Johnson. I'm an immigration officer from the Home Office.
Thank you. Then questions may be asked by the Metropolitan Police. Then questions may be asked by the premises license holder. Then questions may be asked by members of the committee and our legal advisor. Next, the responsible authority, Metropolitan Police Services, will present their submission. They will have up to a maximum of 10 minutes to do so. Please, could you confirm your attendance?
Thank you very much, Chair. It's PC Ian Davis, licensing, Kensington, Chelsea. Also, as a witness, is RBKC Trading Standards lead, Chris Jolly, as my witness. Thank you.
Then questions may be asked by the applicant. Then questions may be asked by the premises license holder. Then questions may be asked by members of the committee and our legal advisor. Here he is. Next, the premises license holder and their representative will present their submissions. They will have up to a maximum of 10 minutes to do so. Please, could you all confirm your attendance?
Yes, good morning, everybody. Noel Samaru from NTAD Consultants.
Okay. Then questions may be asked by the applicant. Then questions may be asked by the MPS. Then questions may be asked by members of the committee and our legal advisor. After this, we will ask our legal advisor to deal with any further questions he may have, and then he will lead on the conditions. Please, could you confirm your attendance? Mike?
Yeah, it's Steve Burnett representing the members of the committee today.
Thank you. And finally, we will turn to the governance team to see if any issues have been raised that we need to consider. There will be no summing up and the meeting will end. I would like to remind everybody that the committee has read the papers, which comprise the main pack, and the additional submissions that have been circulated to the parties. So there is no need, please, to repeat their content, but please do draw our attention to relevant points and pages. Let's proceed. Yes. Sorry? Mr. Daoud, can you please turn your mic on and introduce yourself?
Hi, good morning, everyone. My name is Abdul Basit Daoud. I'm the DPS. Thank you.
Thank you. Okay. Licensing, please, can you outline the case for us and advise if there has been any additional documentation received?
Chair, members of the subcommittee, good morning all. The subcommittee is asked to consider an application for a review of the premises licence for Diana Restaurant and Cafe, basement and ground floor, 5 to 6 Wellington Terrace, Notting Hill Gate, London, W24LW. The application for review has been submitted by S. Prashar on behalf of the Home Office Immigration Enforcement Team under Section 51 of the Licensing Act 2003. The review has been brought forward on the grounds of the prevention of crime and disorder. The Home Office states that the premises licence holder has failed to meet this licensing objective due to the repeated incidents of illegal working at the premises. Across 4 separate enforcement visits carried out between September 2019 and May 2025, a total of 7 illegal workers were identified at the venue, with 1 individual encountered twice. The Immigration Enforcement Team submits that the licence holder, along with the premises management, failed to conduct mandatory right-to-work checks as required by law. During the most recent multi-agency visit on the 9th of May 2025, officers from the Home Office, Police and Trading Standards found that unlabelled and non-compliant shisha tobacco products were being used on the premises, and customers were observed smoking shisha in the basement in breach of the Health Act 2006. It is further submitted that labour exploitation may be taking place, with workers reportedly being paid in food instead of wages, and 1 worker claiming to have been employed for over 2 years without the right to work. Immigration Enforcement has referred to paragraphs 11.27 and 11.28 of the Section 182 guidance, which states that employing a person disqualified from working in the UK is a serious matter, and revocation of the licence, even at the first review, should be seriously considered. A representation has also been received from PCA and Ian Davis of the Metropolitan Police Service supporting the review on the grounds of the prevention of crime and disorder. PC Davis attended a visit on the 9th of May 2025 and witnessed customers smoking shisha indoors, contrary to the legislation. He has echoed the Home Office's recommendation that the premises licence should be revoked. In response to the review, the solicitor acting on behalf of the premises licence holder, SSW6 Holding Limited, has submitted a written apology and outlined proposed conditions intended to remedy the issues raised. These include implementing SIA supervision, compliance training, improved CCTV, digital HR system, and a noise management plan. The licence holder is also proposing a suspension to allow time for these measures to be put in place. At the time of writing the report, the premises had been the subject of 3 noise nuisance complaints in the preceding 2 years and 2 temporary event notices within the past year. There are no planning restrictions relevant to this review. Chair, the options available to the subcommittee today are to take no further action, modify the conditions of the existing licence, exclude a licensable activity from the scope of the licence, remove the designated premises supervisor, suspend the licence for a period not exceeding 3 months, and revoke the licence. Finally, Chair, I can confirm that 1 additional document was circulated at the request of the premises. This document has been referred to as the premises supporting statement. You will now hear from the applicant and those who have made representations. I am happy to provide any further clarification as required. Thank you, Chair. I'll leave it there for now.
Thank you very much. Now for the applicant's case. Home Office, please can you advise if there have been any amendments to your application?
No amendments to the application.
Could you speak up, please?
Yeah, no amendments to the application.
Thank you. Please, can you now present your submission? You have up to 10 minutes to do so.
Okay, I would like to first confirm that the committee members have had time to read the submission pack.
Yes.
Yep. So I don't propose to go through the whole pack, but I will make a couple of key points before I summarise the case. The ability to work illegally in the UK is a key driver of illegal migration. It encourages people to break the UK's immigration laws and provides a practical means for migrants to remain unlawfully in the UK. It encourages people to take risks in trying to enter the UK legally, putting their lives in the hands of unscrupulous people smugglers, and leaves them vulnerable to exploitative employers. Illegal working results in businesses that are not playing by the rules and undercutting legitimate businesses that are. It also negatively impacts on the wages of lawful workers and can be linked to other labour market abuse such as tax evasion, breach of the national minimum wage and exploitative working conditions. Employing illegal workers undermines the licence objectives, specifically the prevention of crime and disorder. Immigration enforcement do not just drive around looking for businesses to target. We are intelligence-led, and there have to be significant concerns for us to action incoming intelligence. We do not routinely refer to seeker licensing review, but we do so in cases where we have heightened concerns. Between 2019 and 2025, immigration officers conducted 4 illegal working visits to Cafe Diana, each uncovering serious concerns relating to illegal working. In September 2019, one Egyptian male was found working illegally. He was on immigration bail and not permitted to work. The owner claimed that he was just helping and was remunerated in food. The visit marked the beginning of a pattern of illegal employment and poor compliance. In February 2020, 3 illegal workers were arrested, 2 Egyptian males and 1 Albanian female, all admitted to working regular shifts for cash or for food. One attempted to pose as a customer, another admitted to entering the UK illegally via lorry. No legal right-to-work status was held by any of them. The licence holder failed to carry out any pre-employment checks. Following this visit, a civil penalty of £10,500 was issued. However, this penalty was later cancelled, with the liable party, Nat and Cafe Restaurant Limited, going into liquidation. In December 2024, 3 illegal workers were arrested, including the same 2 Egyptian males from the 2020 visit and an Algerian female who presented a fraudulent French ID. The licence holder admitted staff were being paid in cash and food and that the CCTV was not operational. A civil penalty of £135,000 was issued for illegally employing the 3 workers. In May 2025, immigration officers was denied entry under informed consent, but during the joint inspection with police and trading standards, it revealed customers were smoking shisha in the basement and the presence of 45 unlabelled tubs of tobacco, indicating serious breaches of tobacco regulations. The licence holder claimed these breaches were attributed to a basement tenant. However, the failure to monitor or oversee tenant activity reflects poorly on the overall management of the premises. Across all visits, there has been consistent failures to meet the licensing objectives. The prevention of crime and disorder was undermined by repeated illegal employment. There were also concerns about labour exploitation at the premises. Public safety was compromised by the presence of unvetted staff and non-functional CCTV. The prevention of public nuisance was breached through illegal shisha use and poor tenant oversight. Illegal tobacco was seized by trading standards. Several complaints were also received in 2023, which are collated in Appendix E. The licence holder argues that historical penalties were issued against previous operating companies and not against SSW6 Holding Limited. However, the premises, staff and management practices have remained largely unchanged. The responsibility to ensure lawful operation lies with the DPS, Mr. Abdul Basit Daoud, regardless of the company associated with the civil penalties. It is noteworthy that Mr. Abdul Basit Daoud opened the premises in 1989. The premises licence was held between 2017 and 2024 by Wellington United Limited, of which Abdul Basit Daoud is and still is the active director of. The claim that the May 2025 breaches were attributed to a basement tenant does not absolve the licence holder of responsibility or the DPS, as they are accountable for activity on the licensed premises. The repeated nature of these breaches over a 6-year period raises the question of why it has taken the licence holder so long to take meaningful action. Despite multiple enforcement visits, arrests and penalties, there is no evidence of improved practices, staff training or compliance systems. This ongoing pattern of neglect and failure to uphold the licensing objectives warrants serious consideration. Section 182 guidance at point 11.27 outlines certain criminal activity that may arise in connection with licensed premises, which should be treated particularly seriously. This includes employing a person who is disqualified from that work by reason of their immigration status in the UK. In this case, illegal tobacco was also seized, which would fall under one of the activities described in 11.27. Point 11.28 states that where a review arises from such activity and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that the revocation of the licence, even in the first instance, should seriously be considered. We recognise that our role is to bring these concerns to your attention as a local licensing authority. This is your area and it's you to answer to the electorate and represent the interests of local people. In line with the guidance, the Home Office Immigration Enforcement is seeking for the subcommittee to consider revoking the premises licence. And unless I can answer any specific questions, I don't propose to take any more of your time, and thank you for your attention and considerations.
Thank you very much. Any questions from the MPS?
No questions.
Okay. Any questions from the premises licensing holder?
No, Chair, no questions.
I know my committee does have a lot of questions. We'll start with Councillor Rossi.
Okay, I will start with two questions. These visits started in 2019 and went on to this year. So my first question is why it has taken the Home Office so long to request this review. And secondly, if you could clarify for me, I think you said in your sort of testimony that Mr. Abdul Dawood was still active in the new company SSW6. So could you just clarify that for me?
Just to clarify, the company that I mentioned was Wellington United Limited, which Abdul Basit Dawood was the license holder. Sorry, he was the active director of between 2017 and 2024, which were the period when the visits were conducted, and he is still the active director of Wellington United Limited. In regards to how long it's taken the Home Office to put forward a licensing review, as mentioned, it is something that we do take extremely seriously. On the first visit, there was just one illegal worker encountered. There was a period of 3 years in between. However, since that time, we've got heightened concerns. So from February 2020, there was then 3 illegal workers encountered. And in December 2024 was then when we realised the same 2 workers, the Egyptian males, were still working there from 2020. And following our visit with the multi-agency visit, which is then when we put the review in to raise our concerns about its premises.
Okay, but I mean, some people could say it's taken rather a long time for you to get round to this, and perhaps you should have asked for a review earlier.
Yes, that is noted. That's accepted.
Councillor Noor.
I have a couple of questions, but the first one, can we ask the 135K fine was paid, and who paid, and when it was paid?
I don't believe we have the information about if that's been paid yet.
Sorry, didn't you say, unless I'm mistaken, that the $135,000 fine was charged to a Wellington company that then went into liquidation? So would that assume that they didn't pay it?
That was the initial £10,500 penalty, which was issued following the 2020 visit. That was issued to a company listed as Nat Cafe and Restaurant Limited, which went into liquidation. So that one did not end up being paid. The subsequent penalty following the December 2024 visit was £135,000. But that was not given to Nat Cafe and Restaurant.
So who was it given to?
That was given to the Corporate Meeting and Event Services Limited, and that was issued on the 24th of April 2025.
And was that paid?
We don't have an update about if that's been paid yet or not.
Right,
So that's a don't know.
right. So we want to work with you here, but we're missing some key things. The first thing is why it took so long to enforce, or to try to enforce. And number two, why nobody knows why the fines weren't paid. Wouldn't that show some kind of a pattern?
So just to mention about license review hearings, so they're one of a number of tools available to us. So we do also, first of all, we've gone through the civil penalty route, which is to try and engage with the premises, get them to conduct the checks properly by going down the civil penalty route. That has then obviously, in the first instance, the company that was there went into liquidation. A civil penalty has then subsequently been issued to the next company that's there in an attempt to get the premises to conduct the correct checks. Following this, then is when we've been back with the multi-agency operation, and they've then found also additional concerns regarding illegal shisha in the basement. So this is just a number of tools we use. We also have the option of closure notices, licensing reviews, civil penalty, employer engagement. There is a lot of different options. We started with the civil penalty option, and it's now moved on to licensing review option. We've got serious concerns about the premises.
Can I just say, I don't understand why you don't know whether the fine has been paid or not, because I think we would feel as a committee it is of interest whether that fine has been paid and who indeed paid it.
So the fine is administered by a separate team within the Home Office. That would be under the Civil Penalties Compliance Team, which is within the Home Office. We work for Home Office Immigration Enforcement, which is the local enforcement team. So we are the ones who would go out and investigate any illegal working concerns at the premises. The decision to issue the civil penalty comes from a separate team in the Home Office, and they're the ones who issue the penalties to the company. And if that's not paid, then they are the ones who, again, follow up with debt collection agencies to make sure the fine is collected. They're the ones who decide who is responsible for the civil penalty, the company liable, and follow it through to the fine is completely paid.
I think Trading Standards wants to say something.
If I could be of assistance to the committee, the company that the Home Office have mentioned, the Corporate Meetings and Event Services Limited, for which the £135,000 was fine, if it effectively was placed on that company. The director of that company is Mr. Dawood, and that entered voluntary liquidation last month.
Did you hear him?
So is it paid last month?
No, the company entered voluntary liquidation last month.
Okay, so they're avoiding.
Sorry.
To be precise, on the 12th of June, is, according to Companies House, is when the appointment of a voluntary liquidator.
You please speak into the mic. Yeah.
Sorry, on the 12th of June, the, it says here on the Companies House that the appointment of a voluntary liquidator was placed upon that company. It's a record in Companies House.
So we have no confirmation whether or not this $135,000 fine has been paid.
Well, given what trading standards have said, if the company that it was issued to has now gone into liquidation, and the person who was in charge of that company was Abdul Daoud, he would be able to tell you for sure if he's paid it before
Okay,
going
we'll
into
ask him
liquidation.
I mean, my question is, did the Home Office inform? I mean, we know these premises have been through different companies. So the current operator, SSW6, have you informed your concerns of what was happening during their involvement?
So when the enforcement team will attend the premises, they will speak to whoever's in charge of the premises. So you'll see in the pack that there is illegal work in employer Q&As. So they'll be speaking with whoever is in charge of the premises at that time to raise their concerns. So they'll say, for example, we've arrested these two males in the premises today. They don't have any right to work. They'll explain why they don't have any right to work, and they will get the questions and answers from the person running the premises at that time to obviously explain to them that they are not allowed to work and to get their side of the story about why they have not conducted the right checks or what's gone on there. Following that, when the civil penalties team write out to the liable company, they will also set out to them the reasons why that person is not allowed to work, so it will have been raised.
In your investigation and questioning those illegal workers, did you find out where they were staying?
So for each of the illegal workers, they are asked for their contact details. So when they get given immigration bail, they'll provide us with their home address, and from there is where they'll be bailed to set up to their local reporting centre. Nobody was found to be living on the premises in this occasion.
Councillor Rossi?
Yeah, just to clarify, because I don't think I quite heard, did you actually inform on, you went December 24, did you actually inform SSW6 that you had raided the premises and found illegal workers there? Did you inform that company?
So that would not be something that the local enforcement team that we work for would do. In terms of us, we speak to who is in charge at the premises at the time. So whoever is running the restaurant at the time is who we will have a conversation with and speak to. Following that, the follow-up then goes on to the civil penalties team. So they will then find who is liable for the civil penalty, and they will write out to them.
So, I mean, just making an observation here. I mean, I know you have separate teams to different things, but when you're coming to, a meeting such as this, surely, we need to know if you actually informed SSW6, because these are the people who want to carry on running the premises. So we need to know if they were actually formally told about what was going on.
So I've got nothing noted here. What I would say is that when the licensing review has obviously been raised, they have had the notification of that, and they have had the time to look at what's been presented and to look at that. Obviously, this premises has been run by Mr. Abdul Daoud. He opened the premises in 1989. So this person has a lot of control over the premises. As you can see, there have been several companies involved in the running of this premises. You've had Nat Cafe, you've had SSW6 Holding Limited, you've had the other one, what was the other one? You've had Corporate Meeting and Event Services Limited as well now. So there is a lot of different companies getting involved with the running of this business, and it seems to just be one is passed to the other, one becomes liquidated, it then moves on to another company, which we've now been informed has been liquidated. I understand what you're saying about the SSW6 Holding Limited. I don't have any information about whether they have been informed or not, but as part of the process, the person running the premises has been informed, so they should be aware.
Councillor, can I maybe offer some light for your question here? Yes, there are different companies that have been involved at that premises, but the licence and the leaseholder has only been SSW6 Limited.
This sounds as if it's part of your presentation anyway. So can we...
I was just trying to offer some clarification to the councillor's question.
I think it's best if you give clarification when you're...
Yeah, you'll have your turn. Just make a note to mention that point, please. Well, my committee's asked most of my questions. Are you saying the pattern is, and you can tell me if I'm allowed to ask this, there's a company, gets rated, then they form the same DPS, then they form another company, gets rated, another DPS. Is that the pattern, the overall pattern?
We do see that pattern in a number of premises. Often the limited company is changed to avoid having to pay a civil penalty, but you'll see that quite often the same DPS remains in the premises, the same premises holder is there for the license, but you'll find a lot of different businesses. They do change the companies and liquidate companies, and the civil penalties remain unpaid.
And when you came back and saw the same chap there, still working, who was illegal, and still working there, was it 2 years later? Is there any higher fine you can do, or what is the penalty then if someone remains in situ, an illegal, the same person?
So yeah, the 2 Egyptian males who were arrested there in February 2020, they were found to still be working at the premises in December 2024, so
it's 4 years.
Over 4 years later. In terms of the civil penalties, there has recently been a change to the way the civil penalties are issued. So now the civil penalty for the first illegal worker is £45,000 per worker. For repeated breaches, so if they go back to the same premises and they find illegal workers working there again, it can be a £60,000 fine per worker. Additionally, I would also mention that it is a criminal offence to knowingly employ illegal workers, so potentially there is another avenue where there could be a prosecution made for knowingly employing illegal workers.
Oh, thank you very much. Now, any questions from our legal officer?
This is purely for clarification. I think it's your evidence that you have no records of ever informing SSW6 of the antics of Mr. Daoud. Is that correct?
I've got nothing here regarding SSW6 being notified. However, if they are, the premises holder for the premises, I would expect them to be fully aware of everything that's going on inside their premises.
And secondly, as far as the £135 is concerned, you have no information as to whether or not that's been paid.
No, I don't have any information as to whether that's been paid before the company that was issued to went into liquidation.
Thank you.
Perhaps the applicant will be able to answer that when it's their turn. Okay, now for the responsible authorities case. MPS, please, can you present your submission? You have up to 10 minutes. That'll be you, Ian. Thank you.
Thank you very much, Chair. And thank you very much, Home Office, in relation to your submission. I'll be quite brief in relation to these premises. What's been identified and said is quite concerning. I attended on the 9th of the 5th alongside a multi-agency visit in relation to information that there'd been ongoing concerns around illegal workers from local ward councillors. Having attended, to summarise, there was a number of shisha smokers in the basement. Quite a lot of shisha products was confiscated by RBKC trading standards at the time. And since then, in relation to the police position, fully supports the revocation of this licence and detailing the 182 guidance in relation to 11.27 that there is certain criminal activity that may arise in connection with licensed premises should be treated particularly seriously if these premises are used for employing persons who are disqualified from working. Plus, I would also like to reiterate the aspects of the deterrent factor, which is identified, and I'd refer to the East Lindsey District Council v Abu Hanif, whereby a late night refreshment venue was identified as employing illegals, and as a deterrent, the venue was summarily, the licence was summarily revoked. That is going to be my submission, Chair. I'd like to also, in relation to any questions along the confiscation of shisha paraphernalia and products, I've got RBKC Trading Standards Lead, Chris Jolly. Thank you. That's my submission.
Thank you. Would you like to say a few words?
Yes, thank you. I'm Chris Jolly, as Ian has identified, and I act as the Deputy Trading Standards Manager for Trading Standards. On the 9th of May, just to confirm, 21 kilograms worth of illegal illicit shisha was seized. That has a value of around about £2,000. Furthermore, as Ian has identified, there were considerable breaches of the Health Act 2006 in that people were smoking in a substantially enclosed area. These matters are being currently investigated by officers of trading standards and to identify who is responsible, one, for the sale of the shisha, the illicit shisha, and two, for who has allowed the smoking in a substantially enclosed area. So the aforementioned companies that we've spoken about today and the individuals concerned are all under investigation criminally for those breaches under the Health Act and tobacco-related products regulations. I don't think I need to say anything more, but I am happy to answer any questions you may have.
Thank you very much. Now, any questions from the applicant?
No questions, Chair.
Any questions from the premises license holder?
No questions, Chair.
Now, any questions from the committee?
Sorry.
Sorry, the whole, it says here premises license holder. Oh, you're the applicant, okay, sorry. Yes, do you have any questions?
No questions, Chair.
Thank you. Okay, any questions from the committee?
Not from me.
Any questions from our legal officer?
No, not from me.
Okay. Now you'll have your time. Premises license holders case, please can you present your submissions? You have up to 10 minutes each to do so.
Yeah, thank you very much, Chair, and good morning to everybody. It has already been confirmed that we did send in a supplementary document that you've been confirmed that everybody's had the opportunity to read. However, I respectfully submit to the committee that revocation of this premises licence is contrary to the statutory aims of the Licensing Act, and every other option should be sought before revocation is applied. The majority of the enforcement action cited relates to former companies. Now, I know there's been some confusion this morning about who operated it and what company was fined and what happened. So some clarity would be that in 2019 to 2020 was a company called Nat Cafe and Restaurant Limited. They were the ones that were actually trading in the basement of those premises. The licence holder was a company called Wellington United. And they were the licence holder, I think, up until roughly December 2024, when that licence was then given to SSW6 Limited. So there have only been two particular trading companies that have held the licence and held the lease on those premises. Now, what's happened in the meantime is they have sublet the basement area to a company called Cafe and Restaurant Limited, Nat Cafe and Restaurants Limited, that were involved with the incidents between 2019 and 2020 when some illegal workers were found. They were not employed by Cafe Diana. They were not employed by Wellington United. However, that doesn't mean to say that Mr. Daoud, who has been operating those premises for 36 years, has no responsibility over what's going on in his premises. But it is fair to say that he was not aware. In December 2024, when the premises was raided again, the operating company downstairs was a company called Corporate Meetings and Event Services Limited. They had been found to have 3 illegal workers. And I think, yes, there was a fine that was given to them. And that fine has not been paid because Corporate Meetings and Events Services Limited are in liquidation. However, Mr. Daoud does not want to sidestep his responsibilities as the DPS. He's been there, he's built that business, as I say, for 36 years. But the severity of the situation with illegal workers, he has taken very, very seriously. The Shisha tobacco seizure, again, was attributed to the Corporate Meeting Event Services Limited, who were operating the Shisha downstairs in the basement. And I think you've seen from the material that was sent to you that we, or Mr. Daoud, is trying to take some remedial action immediately when he was notified by his staff that what had happened. And I have to say, he has not received any notification from immigration regarding what happened. But he took it upon himself to immediately terminate the management agreement that he had with Corporate Meetings Limited, and they were basically thrown out of the premises because of the issues with the illegal tobacco and the illegal workers. I don't think there's any evidence of systematic illegal working practices under the leaseholder, which is SSW6 Holding. Yes, they have been, I think negligent would be too strong a word to use, but they've been trusting that the companies that they've allowed to operate in the basement are going to operate legally and properly. But it's not until they identify to them that things are going wrong that they've had any reason to take any action, which they have done in each case. They immediately terminated the subletting. They have put in comprehensive protocols now that they will monitor the staff of even a company that is running their own business in the basement. They will now monitor the staff and do work checks under the Immigration, Asylum and Nationality Act. So they're even though they should have taken on that responsibility first, they felt that a company who was a limited company employing people, they should be doing their checks. And they, as the leaseholder and the licence holder, they now feel they should have done more to ensure those people were doing the correct things and not employing illegal workers or using illegal shisha. They would also implement comprehensive recruitment controls and protocols with mandatory right-to-work checks aligned with the Immigration and Asylum and Nationality of 2006, and also use the Home Office online status verification system before they would allow anybody to work on their premises, whether it's for them or if it's for their tenant. Those things now have to be outlined to SSW6. They've also taken on an independent company to do quarterly checks, and that will be through an independent consultant or through their accountants, who will also hold exterior records. But the records will also be on the premises for police or immigration or any of the responsible authorities to check when they do their checks. The statutory framework for proportionality in this case, and it is a complex situation. Everyone has tried to make it, very plain and simple, but it's not quite that straightforward. This business has been there, as I said, for 36 years, and there's been a lot of press coverage, as you're probably aware, where things have been said in the press regarding Cafe Diana itself, which are not correct. So I just wanted to make that point, that under paragraph 11.2 and 11.23 of the Licensing Act, it's important to try and identify the root cause and offer appropriate, targeted and proportionate response to what's been going on. I heard earlier that the Home Office said they would do a number of steps before they came to support or submit a revocation. None of those steps have been met at all. They've had no communication with anybody at the premises. They had no communication with Mr. Daoud, who's the premises licence holder, to help him and offer him advice as to what he should be doing. So it's only after this situation when Mr. Daoud approached an independent company and said, look, this is what's happened, what should I have done, or what can I do to make sure this doesn't happen again? None of that support or information came from the Home Office or anybody else. It was given to him by outside, independent, his legal advisor, and those steps have now been put in place. However, there's things that still need to be done, committee, and one of those things is how is he going to, if he's going to want to rent out the basement area, how is he going to do that without this situation going forward and people just being able to blame somebody else? What he's proposing is that to separate the premises, because at the moment the address is basement and ground floor, is to separate the premises, and if somebody wants to take those premises independently, as they have in the past, they should apply for their own licence and have their own DPS. That way they are directly responsible for their premises. The situation here that's made things slightly complicated is that you've got somebody else running the premises downstairs, but then Mr. Daoud is responsible for the whole premises, and sometimes people are not willing to give information as they should be to Mr. Daoud. He's also, in the paperwork he sent to you, said that we would except a change of DPS. Mr. Dawood's health over the last couple of years has deteriorated.
Summary,
hasn't.
That's 10 minutes, so if you want to finish.
Okay, it hasn't been as at the premises as much as it should have been. So I think that really, to run out of time, basically wraps up our representation, tried to give you an overall view of the whole situation.
Now, does the applicant have any questions?
One question I've got is that you said that Mr. Dawood hadn't been sort of explained or made aware of what's been going on, but we've got two interview records here of him being spoken to 18th of December 2024 in regards to the illegal workers, and again in 2020. So in 2020, he was told that the 2 Egyptian males were not allowed to work there. And in 2024, again, obviously, he was still at the premises, and the 2 Egyptian males were arrested again. So just wanted to get some clarification about that.
Mr. Dawood said it's so long ago he doesn't really remember the details of what went on. But as a correction, what I did say was that Mr. Dawood hadn't received any help or guidance from you, as you mentioned in your statement, that was the process that he should have gone through. And maybe we wouldn't be here today if he'd received that.
Any questions from the police?
Yes, Chair. In relation to SSW6 Holding Limited, why isn't the company director here a Monica Eva Zabreska?
We did ask her if she could attend this morning, but she also has another job, and she just couldn't leave her other job to be here. Otherwise, she would have been. She is fully aware of what the situation is and what's going on.
I mean, my concern is the fact that the company director is not here in relation to serious allegations of illegal employers and criminal activities, employees. And another question in relation to that, why wasn't an adjournment requested by the company director if she couldn't be present?
A good question. I don't know why she didn't request an adjournment. Whether the company's legal solicitor had advised her on those things, I don't know. But that's not something I personally dealt with.
Thank you. In relation to your bundle, and you can clarify if I'm incorrect in identifying that, am I right in saying that Mr. Dawood is not going to be the DPS moving forward?
Correct. I mean, he has openly said that his health is not as good as it was. He can't be there as much as he should be. And one of the things that we propose that we have enough time, if there's a slight suspension put in place so that we can get all these things sorted. We can change the DPS or find someone that's capable of running those premises on a day-to-day basis, which would obviously help this whole situation. So yes, to answer your question.
And thank you, Committee. Just for my last question, what's been Mr. Dawood's involvement in relation to employing staff?
Mr. Dawood doesn't employ staff. He's the DPS there, so he hasn't been involved in the employment of any staff members as far as I'm aware. The staff that you're referring to have been employed by different companies that are operating in the basement, not SSW6 or Wellington United. Those have been the 2 licence holders and leaseholders of the premises. I think where your question's aiming in is why haven't they? And that was simply because they had two or three separate companies that were recruiting their own staff. And they would have believed that they would not have recruited illegal workers. But when they found out they did, they instantly terminated their agreements and got rid of them. But it comes back to, again, maybe this could have been avoided if he had been approached earlier about his responsibilities regarding downstairs.
But in response to that, I'd say that through his training in relation to being a DPS, he would have been mindful of the concerns around employing illegals and that being in that working environment. Am I right in saying that?
Yeah, I mean, you're aware of what the APLH level 2 is involved, but as a DPS, yes, he would have maybe involved in the employment of people who were with Wellington United or SSW6, but he would not have been involved in the recruitment of staff for a totally separate company.
Thank you, Chair. That's my questions. Chris Jolly would like a question, if that's possible.
Thank you. Just for clarification, I understand from what you said in your submission that as DPS, Mr. Dawood terminated his agreement with Corporate Meeting and Events Limited, who are running the basement, on the 9th of May, on the night that we're talking about with when we found illegal workers and the potential criminal elements in regard to the training standards matters. As we've already heard, from what I'm getting from that, and I seek your clarification, that Mr. Dowd has effectively terminated a contract with himself because he was the director of that particular company. Is that correct?
I think that was was Monica, who was the director, terminated that company, yes.
So on the 9th, Corporate Meeting and Events Limited were running the basement area, of which Mr. Dowd was a director.
Sorry, we just need to be a little bit cautious because you're still investigating trading standards matters.
It's a clarification point because it was raised in his submission. I think it's a reasonable question to ask, given that it was raised by the respondent.
I hear what you're saying, but I still think we need to be a bit cautious because there's ongoing investigations going and we can't have him incriminate himself without being cautioned, etc. Okay, sorry.
Now we'll have questions from the committee. Councillor Rossi, please.
Yes, Mr. Samari, thank you for your testimonial. The police have already partly asked my question, but just for further clarity, are you representing here today Mr. Dawood or SSW6 Holding Limited? Why are you here and who are you representing?
I'm representing both, Chair.
So then I would echo what the police officer has said, that it is really, very disappointing that a director of SSW6 is not here in such a serious meeting. So therefore, I would like to go backwards now to December 2024. I think you told us when you thought SSW6 took over, but I am informed that SSW6 took over running the premises on the 25th of January 2024. So they were actually the licence holder in December 2024 when illegal immigrants were found to be working on the premises. So could you clarify exactly when SSW6 took over the premises?
Yes, Councillor, you're right. They took over the premises as the premises licence holder and the leaseholder in January 2024. However, the company that was found to be employing illegal workers in the basement was Corporate Meetings and Events Services Limited.
So that was Mr. Dawood's company, yes?
He was the director of that company.
Yep.
Yeah.
So you're saying that in 2024, two companies simultaneously held the license. One was for the basement and one was for the upper floor. Is that what you're describing to me?
No, Councillor. That's what I wish had been the situation. But Corporate Events, Meetings, Event Services Limited did not hold the licence. The licence was held by SSW6.
So the point I was trying to make was at the time that illegal immigrants were found working in December 2024, the premises licence was held by SSW6.
Correct.
Okay, thank you.
Yes.
Councillor Noor.
Thank you, Chair. Can I ask, in the last visit of the immigration officers, why they were not given access to the property?
Sorry, Councillor, I can't hear you very well.
In the last visit of the immigration officers, they were not given access to enter the premises. Do we know why?
They were given access. I think questions were asked as why they were there, but they were actually given access.
I mean, as far as we know, the police was into the building, but not the immigration officers.
As far as I'm aware, the agreement, eventually, the immigration officers were given access, because in their statement they said they spoke to somebody who they suspected of being an illegal worker, but wasn't. No one was arrested under immigration this time, but the police, I think, was given access, and so was Trading Standards.
Sorry, can I?
Oh, sorry.
Sorry, can I just interject? So on page 32 of the bundle, this is the evidence from the Home Office.
Sorry.
This is evidence from the Home Office. Page 32, I think. It talks about the enforcement visit on the 9th of May.
Yeah. Mm-hmm.
The first paragraph talks about a multi-agency operation. Officers from Central London ICE arrived at the premises at 23:29. Officers attempted to gain entry by fully informed consent. This was denied. Are you saying that part of the evidence is incorrect?
I'm not saying it's incorrect. It may have been denied at the time, but they were eventually given entry. Mr. David wasn't there, unfortunately. I think the manager at the time was a little bit confused as to should he give them entry. We know that they have every right of entry with the police and Trading Standards. But I think questions were asked, and then I think they were let in. So it wasn't that they were denied entry, they were just asking questions as to why they were there.
Can the Home Office please clarify that point?
Hi, I'm Callum. I was present on the visits of that evening. Yeah, as it states in the briefing pack, we did attempt to gain fully informed consent from the person in charge. That was refused. and then we were off scene for the remainder of the evening. A few officers did stand by while police and trained standards entered, just for support, but most officers were stood down and we did not enter the premises at any point that evening, other than to gain the informed consent.
Chair, I've got another question. I mean, we've seen the history of Mr. Dawood's involvement all through going back to 2012, if not before. So I just want to ask the relationship between SSW and Mr. Dawood. I mean, we understand SW are now the license holder. It's also clear that Mr. Dawood has directly, indirectly owned different companies who run part of the premises, especially in the basement. So what's the relationship?
I'll try and answer that. Mr. Dawood's here, maybe he'll answer you better, Councillor. Mr. Dawood is not a director of SSW6. Correct?
That's correct, yeah.
The main reason for that, as I said, his health has not been that good, and he didn't feel that he was able to take on that role, but he remained the DPS on behalf of SSW6 on the premises licence that they have.
But I thought you said that his health was failing and he was no longer going to be the DPS.
That's right. But up until today, he still is. But as you see that he, with all that's happened, he just feels that he's maybe not up to the job now and recognises that and wants to step aside, but would like to be given, rather than a revocation of that licence, be given a little bit of time to sort those issues out and do a variation to submit a new DPS.
Chair, it's just related to the same question. Is the reason I'm repeating is it's clear Mr. Dawood's involvement goes back to about 36 years. So we need to be clear here. I mean, if he's going to step down as a DBS, then will he have other involvement running this business, not being DBS?
Now, you have to take into consideration that he is the founder of this business. He's been there for 36 years, every step of the way. So, you know, it is fair to say that mistakes have been made. It is fair to say that he's recognised those, he's done what he can, but he feels going forward that as the responsibilities for the designated premises supervisor, as for the day-to-day running of that business, he feels that somebody else, I mean, he's nearly 70 years old, he feels that somebody else, maybe modern-day experience and somebody with a bit more vitality would be better off operating the business as the DPS.
Can you tell us, Monica, what is her experience and background, her professional experience?
Well, Monica's been there for some time. I think she was working there when she took over the business as a director when it became SSW6. But I'd have to ask Mr. Dawood how long she's and what experience she has.
Hello, yeah. Monica, she's only the leaseholder. That's it. And she's as a landlord. Simple as that.
So she has a financial interest in the business?
Hardly.
Sorry?
Hardly.
Hardly, but
because
she's a landlord.
yeah, she's a landlord. She's trying to survive. Yes, as a financial, from renting it to a tenant. Now she's got no tenant, looking for a new tenant. And a new DPS.
You know, this is beginning to sound like the song, It Wasn't Me. Because, do you know that song? It's sort of, there's a little bit of evidence, and then we ask a question, and then it wasn't you, and you've been in the business 36 years, and it wasn't you. So I ask, what was your responsibility? And if it wasn't you, who was it?
The responsibility of the DPS, Chair, as you know, is the day-to-day operation of those premises to ensure they run legally and that the conditions are being met. As far as the directors of the company are concerned, they are there as company directors to make sure that the company acts properly. As the leaseholder, the licence holder, the same applies as to the DPS. Really. The licence holder's responsibilities are to ensure that the premises are run lawfully. As a leaseholder, I'm not legally qualified to explain that one, but I would think that they are responsible for the operations of the premises under the lease. So it's not a matter that we're trying to sidestep, we're just trying to say to you, there have only been 2 companies that have held that licence. The difficulty for them has been, their mistake has been to let other companies trade in the basement without having their own licence. So when they trade incorrectly and do things wrong, obviously it comes back to the premises licence holder, which they've agreed. They're not trying to say it wasn't us. All they're trying to say is that whatever's gone on in the basement with the illegal workers and tobacco was other companies that were doing that trade under their own limited company. Their problem is that, as you quite rightly say, they've got to put their hand up and say, look, we made a mistake. We should have either not given it to anybody else to run, or if we are going to give it to somebody else to run, we should have had them apply for their own premises licence for the basement. And then they would be here in front of you, and not Mr Daoud and not SSW6. So they're not trying to counsel say it wasn't me. They're saying, yes, it was us, but we made a mistake by allowing them to do what they did. And part of the submission to you answers your question by saying, if you give them the opportunity, they will put this right. Anybody that's taken the basement, they will then put in an application for their own licence, and Mr Daoud will step down as the DPS for the existing licence until they can find somebody else to replace him.
So what you're saying is your recommendation is that the downstairs applies for their own license. Is that what you're saying?
Yes, any future business that was to take the downstairs basement, it'd be under the condition that they apply for their own licence. I know that licensing have been to the premises and they can see that downstairs is closed. There's a lot of work going on there to permanently separate the two premises. So they can apply for their own licence under a sublease from SSW6, but they must have their own licence there for whatever trade they choose to do.
Right, that would be subject to planning, of course.
Yeah.
Now, Mr. Daoud, how much time did you spend at the premises? Because how could you not notice that the same illegal chaps who were there for, was it 2 years or 4 years? You wouldn't notice, or you can't tell that it's asylum seekers? I'm a little curious about that.
My opinion, they had a right to work. But again, I didn't find out until this right to work has been lapsed. So that's I only knew recently. But they did have right to work before, but it's been lapsed.
Has it? He says they had the right to work that lapsed. From what I see in the papers, it was this, people who did not have the right to work. So can you clarify that, Home Office?
Yeah, I'm just looking at the two gentlemen now. So the first one, he had no right to work. The second one had entered on a business visit visa and had an asylum claim for protection. So yeah, they didn't have a right to work. It's not that they had a right to work at this premises and it lapsed. They shouldn't have been there.
Thank you. And so for your own workers, do you have a book of records, of employees' records, or is it online, or where do you keep your employees' details?
As we said before, Chair, this is something that now, because of all what's happened, they've put in place. They do the checks, whether they have, if they hold British passports. Obviously, that's not the case, but they just keep their standard employment records, address, date of birth, that sort of thing. If they don't have a British passport and they hold a foreign passport, then the checks will be done to see if they have a share code with the right to work, and that will be kept up to date, and all the normal necessary things that an employer should do when they're employing foreign workers. Unfortunately, this wasn't done before because they didn't know what they should have been doing, and more so that they should have been keeping a better eye on the people downstairs. But those checks are now in place.
So how do you do your PAYE? You must have details, bank details, national insurance numbers, or you have a good memory.
No, I don't think they have bank details, but what they would do, they would give a copy of their passport. That is then checked, and if it's a foreign passport, then they have to give what is called a share code. And the share code is what is issued by immigration to say they have to right to work, and it's got their photograph on it and a share code number, and that has to be kept on file.
So I don't understand. Did you pay them in food, as the papers say, or how did you pay them? You must have had a PAYE.
We didn't. Well, SSW6 didn't pay them. They didn't work for SSW6. What was going on downstairs and what they were doing, we have no idea. But I don't want to get back to it wasn't me. Our responsibility was we should have known, but they didn't.
I do have further questions, but I'll leave it at that. We see the pattern here. I think my committee would like to know something else.
I would like to go back to Monica. I'd like you to clarify, really. Are you saying that Monica used to work in Cafe Diana? And if she did, in what capacity? And is she still working there?
As I said, she's a leaseholder and nothing to do with the operation. And this is the only answer everything.
Okay, thank you.
We'll take a 5-minute break now and then come back and start dealing with the conditions, please. So please come back in 5 minutes. Thank you very much. Okay, we'll now ask our legal officer to deal with the draft conditions and any other queries he may have. Please feel free to contribute because it's a discussion.
I've got some points of clarification required. Mr. Samaru, you stated that you're representing SSW6 and Mr. Dawood. There clearly is an issue in relation to that, because in your evidence you stated that the director worked at the premises, and that directly conflicts with what Mr. Dawood has said. Are you taking instructions from Mr. Dawood, or are you taking instructions from the director of SSW6? No, SSW6.
I'm taking instruction from Mr. Dawood.
So, okay. So you are not, in effect, representing SSW6, is that correct?
Yeah, I'm representing SSW6.
Okay, okay. Has Mr. Dawood got authority to speak on behalf of SSW6 then?
Yes, he has.
And historically, as far as license applications are concerned for Diana's Cafe and Lounge, it's always been Mr. Dawood who has liaised with the police and the licensing authorities. Is that correct?
Yes, as his role as the DPS, yes.
Well, the applications are made by the premises license, but premises license holder, but he has got authority to liaise with the police and licensing authority.
Yes, he has. Yes.
He has. I note your comments in relation to the guidance, Section 182 guidance, and your assertion that any decision should be proportionate, which is accepted, but you have not referred or taken into account the paragraphs 11.27 or 11.28. You've made no comments in relation to that. So, namely that certain criminal activities may arise which should be treated particularly seriously, and this includes illegal workers. And then 11.28, which I think it was recited by the authorities, it is expected that revocation of a licence, even in the first instance, should be seriously considered. Have you got any comments to make about that, or is that accepted?
I think that has to be accepted as it's part of the guidance. However, I did say at the beginning that you should also need to take into account that he has put his hands up to it. He hasn't denied it. So yeah, that's for you. That's for you to decide on how you proceed.
Other questions following on from that? Or shall I go on to the conditions?
Yes, we'll carry on straight to the conditions.
Has all parties seen the conditions which were sent out? I think it was sent out yesterday. I won't run through them in detail, but certainly in relation to the conditions proposed by the PLH, by the premises licence holder, and that's by way of a letter which was sent on the, well, it's dated the 27th of May, it's at page 999. If the committee were minded to allow the licence to continue, condition 23, the proposal is that a minimum of X amount of door supervisors shall be on duty at the premises at all times whilst the premises is open for business. Would that be acceptable?
Can I just have a second to confer with my client?
Have you not had a chance
I've seen
to...
it, but it's because it's got a minimum of X, and would that be a minimum of 1? It is a small premises,
No,
so
it wouldn't be 1. Two door supervisors. A minimum of 2 door supervisors would be better.
may I just spoken to Mr. Dade? He feels that it's a small cafe. There have never been any incidents there of violence or antisocial behaviour, and they sell very little alcohol there. So, you know, an SIA door supervisor is just putting extra financial pressure on them that they can obviously do without, but they feel it's just unnecessary.
It would be a minimum of 2. What you're saying is that because of financial constraints, that wouldn't be workable. In that case, why did the premises licence holder, SSW6, propose engaging SIA licensed door supervisors in their letter?
Is that the letter from their solicitors?
Yeah.
I didn't write that letter, I'm afraid.
Right, okay.
Can I just maybe surmise that if they have as Mr. Howard said, have a big event, or if it could be set with a minimum number of people, it's not the fact they don't want an SIA door supervisor there. It's just that if you have a door supervisor and they've got 5 customers in, it seems a bit odd. But maybe it could be set in relation to a minimum number. If you have more than 30 people or 40 people, you have to have an SIA door supervisor. But maybe that's something that Ian could probably help with, and I don't know how the police feel about that.
Would it be suitable to have the requirement for door supervisors on Thursday, Fridays and Saturdays? Are they your busiest days?
To be honest with you, the busiest days during the daytime, it's a cafe. with children and
Yeah, it's a
door
cafe with
supervisors
children,
just
but
isn't
the condition was
really
offered by
relevant.
the condition was offered by your client. It's not one we've imposed. It's right. I hear what you're saying anyway. Yeah. We'll move on to the second condition. No music or amplified sound should be generated within the premises so as to give rise to nuisance within neighbouring dwellings. That's condition 24.
Yeah, that's fine.
And then there's a condition, external doors and windows. External doors and windows of the premises shall be closed, save for immediate access and egress, from 2200 hours daily until the premises closes to the public and at all times during regulated entertainment. Is that acceptable?
Again, Mr. Daody is saying to me that they've had no incidents there or issues there with noise. They're on a main road, but to close the doors and windows at 10 o'clock when their licence is until 11.
Okay. Again, that was offered by the premises licence holder who you represent. So, all staff who are customer-facing, supplying alcohol or responsible for the selling of alcohol under the Licensing Act shall receive suitably qualified training, regular training and refresher training at intervals of no more than 12 months in terms of promotion of the licensing objectives, offences committed under the Act and conditions of the premises licence. I've added in there, and legal right to work obligations. Written and signed records of such staff training shall be retained for inspection and kept at the premises for all staff and made readily available on the request of the police or an authorised officer of the City Council.
Absolutely.
Available on request to the police or an authorised officer of the City Council. I'm going to add in there the Home Office as well. Home Office enforcement team. There's a condition which relates to CCTV, and again this was offered by SSW6. Basically a CCTV system, actually that should be a minimum requirement of the Metropolitan Licensing Team, let's put that. I've got Westminster in there, apologies. All entry points to be covered, a system to be continually recording, all recordings to be stored for a minimum of 31 days, and viewing of the recording made available immediately to the police or authorised officer. Is that acceptable?
Yes, that's acceptable.
Yeah,
fine.
and also a member of staff being on the premises who is able to provide footage. Okay? Right. The next condition places an obligation on the premises licence holder themselves or herself. The premises licence holder shall undertake right-to-work checks on all staff employed at the premises.
I think that's normally like a modern-day condition now that's added to most premises licence, so there would be absolutely no reason why we would object to that.
Okay.
And there should be records.
Yeah, I've got records.
You have records coming up.
Condition 30, the premises licence holder shall retain at the premises evidence of the right-to-work checks conducted, either physical or digital. For example, a copy of any documents checked as part of a right-to-work checks or a clear copy of the online right-to-work checks. So that's to be retained at the premises.
That's fine.
Yeah. Copies of the evidence of right-to-work checks for each member of staff shall be made immediately available to the Metropolitan Police and the Home Office Immigration Enforcement Team on their request.
Yep.
The premises licence holder shall ensure that third-party agreements or arrangements in relation to operating the premises under this premises licence includes a requirement to conduct full right-to-work checks on all staff and to comply with the terms of the premises licence.
Yep.
Condition 33, neither Mr. Abdul Basit Daoud or Mr. Ahmed Murray shall financially benefit from the operation of 5 to 6 Wellington Terrace, Notting Hill Gate, London W2.
No, we can't really agree to that one.
Okay. And I was going to say finally, but it's not finally. Number 34, and I've amended this slightly. Neither Mr. Abdul Basit Daoud or Mr. Ahmed Murray shall have any involvement in the operation of the premises, the ownership or management of the premises.
No, he doesn't want to agree to that one at the moment.
And I think you offered a style of condition which would remove the basement area from the ambit of the premises licence.
Yeah, that's correct, only because obviously all these issues have arrived, because they've been operating as two different premises and one's not been licensed. So that's what they want to do, make sure that they're undergoing the work now. I don't know how long that will take, maybe another month or so, because they're putting in a separate entry door so that we can do separate plans and put in an application as a separate premises for their own licence.
Okay. In your recent written representations, you talk about if the committee were minded to provide to give you a suspension, that should be 2 to 4 weeks. Again, from the premises licence holder, so SSW6, Monica, as she's referred to, in her letter from her solicitor stroke non-practicing barrister, they talk about a 3-month suspension, which is the maximum, taking into account the seriousness of this matter. They've offered three months suspension.
I think, as you're quite aware, Steve, that the maximum is 3 months. So, however, I think it's only fair to say that I think my advice would be somewhere between there, enough time for them to finish the building work and put all these things in place for inspection by licensing, the Home Office, the police and trading standards. But I think 3 months is a bit of a push, and I think maybe 4 to 8 weeks they can get everything done. And that can be put as a condition of the suspension, that until those things are done, the suspension is not lifted. But at least it gives a time scale for them to follow.
Legally, we can't do that. We can't extend a maximum imposed by legislation.
Okay.
Can I seek any representations from the applicant and from the authorities?
Committee, just as a point of reflection, I want to make it clear that the police are supporting the Home Office in relation to revocation of the licence, and it's apparent that the 182 guidance has been met in relation to seeking revocation. However, if you are considering conditions, could the following condition be added? And this is a current condition that's on the White Lounge, which is in Beecham Place, and this so stated no tobacco or shisha tobacco products for smoking in a hookah and or associated paraphernalia are to be smoked inside the premises. That's no tobacco or shisha tobacco products for smoking in a hookah and or associated paraphernalia are to be smoked inside the premises.
Do you mind emailing that to me?
Yeah,
I've got the gist of it, but I'll need the wording.
Yeah,
if you could.
Isn't that bona fide? It's against the law to smoke inside. You just want it to be mentioned again? Is that the point?
We've used that condition in relation to another premises, and it kind of, I understand that the committee's perspective on it. It's just an added comfort in relation to them enforcing that condition on the premises.
I understand that condition to be with the intention of preventing shisha smoking at the premises full stop. That includes outside. Is that right?
No, it's just inside. The offence is inside, not outside.
Right. In that case, the chair's right. There's already legislation which prevents that.
Okay, thank you. Other than that, we just seek the revocation. No additional conditions. Thank you.
Thank you. And Home Office?
No, nothing additional from us. Thank you.
Okay.
Do our licensing officers have anything to add?
Nothing from licensing. Thank you, Chair.
Governance officers, anything to add?
Nothing from us at this stage. Thank you, Madam Chairman.
Thank you. We've reached the end of this
Sorry,
meeting.
Chair.
Oh, sorry.
Apologies. My fault. Just one comment from licensing with regards to the possibility of removing the basement.
Could you move closer to the mic,
Of
please?
course, absolutely. Just a small input with regards to the removal of the basement from the licensed area via a condition. You could condition the basement to restrict licensable activities, but in order to remove that licensable area, it would need to be done via a variation.
Potentially, we could impose a condition which says no licensable activities shall take place in the basement area of the premises.
Yes, you could, theoretically, if that was the decision of the committee, impose a condition like that, but in order to vary the plan, it would need to be done via the application rather than done by way of a condition.
Okay, thank you. Thank you.
We've reached the end of this meeting. The committee now has all the information needed, and we will retire to make our decision in private. We will not announce the decision today. Instead, the hearing will be closed. A summary determination will be sent to the parties within 5 working days of today's hearing, and a full decision will follow as soon as possible thereafter. The time limit for appealing the decision will not commence until the full decision has been sent to the parties. Thank you all for attending, and thank you all for your very valuable contributions. Thank you to the committee and to our officers. The hearing is now closed.